and welcome to this series of videos and podcasts about decentralized autonomous organizations, or DAOs. And in this particular recording, we're going to be comparing and contrasting DAOs with traditional corporations and discussing some of the legal and regulatory implications for those similarities and differences. So the legal status of DAOs in Australia is still evolving, and there's really no specific legal framework currently for them. So as a result, it's not really clear whether a DAO can hold assets or enter into contracts in the same way as a traditional legal entity, like a company that has legal personality, or a trust where the trustee can hold assets for the benefit of the beneficiaries of the trust. There are some indications that DAOs may be able to hold assets and enter into contracts in certain circumstances. For example, it might be possible for a DAO to hold cryptocurrencies or other digital assets and to use these assets to support its operations or investments. But what a court would actually decide if anything went terribly wrong is really difficult to actually ascertain. DAOs are clearly entering into smart contracts, but whether or not they have the capacity to contract in a traditional contract form is really unclear. In fact, I would say all indications are that there isn't capacity for a DAO to enter into a contract as such. It might be able to, through its membership process or tokenization process, to nominate somebody to act as an agent, a form of trustee, for the benefit of all of the token holders. And the question would then arise as to whether a trust was created under traditional processes. But it's clearly a fact that DAOs can participate in a range of different and various business activities because they are actually doing it. The question is just whether or not the law will protect the members of a DAO or token holders in a DAO, or enforce contracts for the benefit of a DAO, given its lack of legal structure, particularly in Australia. So as the legal and regulatory implications of the kinds of activities that DAOs do are unclear, and each set of circumstances is going to be case by case, I certainly wouldn't be recommending that you jump out there and set your business up as a DAO to start off with. But there are a range of important questions, and I've got some on the slide. Again, if you're listening, it doesn't matter. We need to be thinking about the legal considerations. So we're thinking about whether a DAO can hold assets, enter into contracts. Should it be paying tax? Is it a separate entity or a taxpayer? Should it be withholding tax if it's employing people? Now, for those of you listening along at home, I would strongly recommend you have a look at the PowerPoint now. I have done my best to make a kind of comparison of a range at a really high level, I have to say, a really high level list of some of the features that we expect from organizations and how they're dealt with by in the different structures. So, for example, a legal personality. A corporation definitely has it. A managed investment scheme, which is, it's not a trust, but it's a form of, or an entity that is capable of investment that's well recognised under the Australian law. It has legal personality through its responsible entity. Partnerships themselves don't have legal personality, neither do associations. And right now I'm assuming that a DAO doesn't either, not without some changes to the law anyway. Liability, on the table here I put shareholders, but I'm really talking about owners, I guess. Now, for both an MIS and a corporation, this is limited to the capital that they have invested. In relation to a partnership or an association, it may well be unlimited liability because there isn't a separate legal entity that stands between them, that places that veil between those owners and the assets and the obligations that they undertake. In relation to a DAO, the literature talks about this idea of diffuse liability. the anonymity or the pseudonymity that goes with the ability to hold assets, including tokens, in a DAO means that it can be very difficult to actually trace who the owners are. Having said that, that's really a practical issue as opposed to a legal issue, as in the way that I think about it. And it is quite likely, as the literature and the academic response so far is, it is more likely that if we have to fit a DAO into a traditional structure, that it's probably more like a partnership than anything else. And if we have a partnership with a silent partner, that silent partner is still jointly and severally liable for the acts and omissions of their partners. And on that logic, the silent token holder might fit in the same boat. Management, directors and officers, or the responsible entity are the people who are responsible for making the day-to-day management decisions of a corporation or a managed investment scheme. Similarly, the individual partners, the buck stops with them when it comes to the management of a legal entity. In an association, we usually have a committee or a board, but in a DAO, so all of those, we've got a centralization, a hierarchical approach, but in a DAO, it's just totally decentralized. We've effectively taken out that intermediary of the board or the management committee, and everything can be executed by votes of the token holders or automatically executed through the smart contracting process. Which brings us to the regulatory framework. And in relation to the DAOs, we have no specific regulatory framework. As I keep saying, partnership law might apply, but it might be different in different places. Now, an organization called Koala with a C, it's the Coalition of Automated Legal Applications, something like that. It will come on a subsequent slide and I'll read it out loud to you properly then. They've recommended a model law for dealing with DAOs, and as we'll get to in a little bit more detail, there has been some indication that Australia would consider that law, although subsequently, so that was a Senate Select Committee in 2021 said that that might be a good approach. Subsequently in 2022, mind you, after a change of government as well, there's been a little bit more pushback on that and some identification of some of the issues that arise. The last thing that I have on the slide, very, very high level comparison, is tax. Now, because a company is a separate legal entity, it is taxed as a separate legal entity at the company tax rates. Managed investment schemes or trusts are similarly taxed independently. Partnerships, partners are taxed at the individual or personal tax rates, as are now an association, an unincorporated association that hasn't actually been registered as a charity or as a not-for-profit in some way. Effectively, this is just another form of a partnership in that sort of context, and members, to the extent that profit is actually returned to them, would be taxed at a personal tax rate. It is more likely that associations are effectively clubs and that their charter makes them not-for-profit, which essentially their rules of engagement are, when it's not-for-profit, they still have to be financially viable, but profits are not distributed to the members. Instead, they are reinvested for the purposes of the organisation. With a DAO, it's kind of going to depend on the rules. At the moment, the indications are that token holders who receive a return would be taxed at personal tax rates, and that the tokens would be treated as a form of security under Australian law rather than as currency as such. The legal status of DAOs is still evolving, and so without that specific legal framework for DAOs, it's not clear whether a DAO can actually do this holding of assets in a meaningful way or enter into contracts. But having said that, it's clear that they are doing these things and that they're making decisions on a day-to-day basis. Again, another one for you listening along at home to have a look at the slides. I've tried to do a comparison on the slides of the differences between the ways that a DAO and a company will make decisions. I think one of the things that's really interesting is at the end of the day, the way the company law has evolved over time, particularly in large and listed companies, shareholders really don't have significant amounts of decision-making power. They have the rights at specific times to vote for board members, but other than that, they really don't have a significant amount of day-to-day ability to interact with the company in any way. Where when we have a DAO, member voting can be ongoing, it's digital, can even be automated using smart contracts without any intermediary, which means token holders can be involved in the day-to-day decisions of how a DAO operates. So have a look at the summary on the slide and think about what that means for the way that you as business people might run your organization if it was actually practical and easy to get input from the stakeholders in proportion to their investment in the organization from time to time. Oh, sorry, just quick look at the notes there to see if I've made the point I want to make, and I think I have. So in the interest of keeping us within time, I mentioned earlier that there was a Senate Select report that was put together in 2021 under the previous government, and quoting from one of the submissions to that committee, I think this really sums up where they landed on the status. The current legal status of DAOs is analogous to the legal status of corporations prior to limited liability companies. In other words, before there was legislation which made it possible for a company to have limited liability, when we only had chartered companies that existed by royal decree. Prior to limited liability companies, it was untenable for individual shareholders to have moral culpability for the action of corporations, as they lacked the power and control mechanisms to discipline errant management. And ultimately, this, as in the report, they work through what these options are and ultimately come up with a recommendation that the Australian government establish a new decentralized autonomous organisation company structure, most likely following the koala recommendations, which I'm going to show you in a minute. So the report gave the recommendations for the Australian government to formally recognise DAOs as a legitimate corporate structure. Actually, the government accepted this, by the way, back in 2021, and since then the DAO regulation roundtable has progressed the notion of an Australian DAO regulation and indicated that this regulation is likely to be a light touch legal framework. It's likely to exclude algorithmic DAOs, so things like Bitcoin, and apply to participatory DAOs, so like Upside DAO, a DAO that I mentioned earlier today. Of course, there are lots of questions that they're going to need to answer in order to do that, like what's going to be the territorial reach? What kind of jurisdiction are they going to try and impose? Will the Australian regulations apply if the DAO does business in Australia, or if it has Australian investors? What is that going to look like? The regulatory structure for decentralized autonomous organizations, the committee at the Senate Select Committee, in considering what the regulatory structure for DAOs should be, heard a range of evidence, including a lot of evidence about the rapid uptake of decentralized finance, so DeFi applications over more recent times. DeFi protocols seek to replicate or to supersede traditional financial services and products by utilizing a decentralized structure that removes the need for intermediaries and centralized control. And the way that Australia has regulated its financial products principally to protect investors is by ensuring that the intermediaries provide proper disclosure, that they know who their clients are, and that they take particular steps to protect and understand both the client and the underlying investment. Of course, since the Banking Royal Commission back before the days of COVID, remember that, it's very clear that most people have a very low level of respect for the intermediaries in the Australian financial services sector. And there is a real push to reduce intermediaries and to use smart contracts and DAOs to provide an alternative mechanism. But of course, that's a completely unregulated mechanism. So DAOs represent a new category of organisation operating on a decentralized blockchain whose operations are predetermined by or through smart contracts. The fact of decentralized ownership, control and operation among network participants means that DAOs don't clearly fall within any of Australia's existing entity structures, particularly not the company structures. Legal liability for members, so the token holders that is really unclear, and the regulatory uncertainty is preventing the establishment of projects on a significant scale in Australia. And so there is an innovation need, or a perceived innovation need, that unless we clear this up, we're going to be behind as a nation on the development of these kind of product and services. The Senate Select Committee took the view that innovation is going to drive economic activity, and so in order to basically make, I think their language was, to make Australia a magnet for innovation, and which will drive jobs and tax revenue, they need to be able to support the DAO, and they need to have an appropriate level of regulation for the DAO. Now, there are some places, Wyoming in the US being the first of them, but also Vermont, that now have legislated structures for DAOs. They see this, and they've done this proactively to attract business activities, because companies are looking, or DAOs I should say, are looking for regulatory certainty, because that reduces their risk if they know that contracts can be enforced or how they're going to be taxed, those kind of things. And the Senate Select Committee was of the view that Australia should take the lead internationally on this. So I mentioned the Koala report before, the Koala Model Law. Koala stands for the Coalition of Automated Legal Applications, but they do have a little picture of a koala on their front page. On the screen, I've got a GIF that I'm hoping would roll. It might not. Let's see. Rolling again now. Basically just showing you what the table of contents is of that law. And it looks at things like legal personality. It looks at what's required to form a DAO. It considers who should be liable and what failure events might be. Also addresses the taxation issues. This, I'm not recommending that you read this, but it wouldn't be a bad idea to have a flip through it, not so much to understand what it says, but to understand what it is that it's talking about, because that can inform your thinking about what you might want to see in a law that addresses these questions. And it's something that we will cover in a lot more detail next week. So, as I mentioned before, the Australian government at the time agreed with the recommendations that were made by the Senate Select Committee in principle. The quote I have on the slide, and I'll read it from you, basically comes from the recommendations or the government's response, where they said that looking forward, Treasury will commence consultation on other important issues, including appropriate regulatory structure for innovative new corporate structures like DAOs, and the viability of a new central bank digital currency, just going back to what we were talking about in the last week or so. So public consultations on the issues were to commence in the second half of 2022. Of course, by that time, the guy on the slide who was the treasurer at the time and whose photo is in the report was no longer the treasurer. On the slide here too, I've basically just highlighted the government's response at the time. So at the time, agreed in principle, set up consultation, planning to have advice to government by the end of 2022. So in October 2022, the Australian Law Reform Commission dropped down its report. I have a slide there with a lot of words on it. Have a look. I'm not going to read them all out loud, but I think there are some important points that I'd like you to look at. I couldn't in good faith ask you to read the whole report, the Financial Services Regulation background paper, but I must admit it is a really good overview of what DAOs are, why they matter, how it fits into the Web3 economy, and what the issues are. So at paragraph 129, they basically say that regulating a DAO like a company would require overriding a range of different elements of the Australian law. And they highlight that underpinning the DAO, as with many other forms of use of a blockchain, there is this underpinning notion of anonymity or pseudonymity, meaning that the requirements of the DAO to register the names of participants as directors, officers, or shareholders, or their equivalent, might actually just be practically not possible. And basically the paper that they're quoting from there is, surprise, surprise, a paper that is in your reading. And Simon Moore addresses a number of the impracticalities as well as the regulatory possibilities that I think you will find super interesting. Again, from paragraph 135 of the report, they also identify some of the advantages then of adopting a corporate form. Firstly, that a DAO could enjoy separate legal personality, enabling it to enter into contracts and to hold property. Yay, everybody wants to do that, right? And then secondly, that the members could enjoy that limitation of liability protection so when there are dealings between the DAO and third parties. From a speech from Joe Longo, which was a speech given to the AFR Super and Wealth Summit in November 2021, he said, to paraphrase a concept familiar to corporate lawyers, to whom does ASIC turn? So ASIC is the Australian Securities and Investments Commission. So who does the regulator turn to ascertain the directing mind and will of a DAO? It's not clear who's accountable if things go wrong or don't go as intended or anticipated, nor is it clear how a DAO itself can be held accountable in a court of law. The policy challenge for traditional forms and methods of regulation is readily apparent. Legal analysis of how DAOs work is at such an early stage with many unanswered questions. What is the nature of a member's interest? Is it like a share in a company or a unit in a managed investment fund? In other words, we still have so many unanswered questions, and it can be difficult to kind of try and wedge this thing called a DAO into a corporate form. So I just want to make a couple of final notes from the Australian Law Reform Commission report. We'll talk about these ideas in a little bit more detail next week, but one of the things that we need to think about as we think about how a DAO should be regulated and whether it's going to be the new form of company is we need to think about whether we're regulating in the right way. And the Law Reform Commission, quoting extensively from a much longer paper, recognised that it's important to ensure that the regulation itself isn't unduly driven by the technology, and in particular, how concepts should be labelled and defined, or in terms of whether new regulations should be created. We've got to be really careful to make sure that we're not just trying to peg a square peg into a round hole. We don't end up creating unnecessary or unexpected byproducts of the problem of calling a pigeon a duck and saying it looks like a duck, it sort of quacks like a duck. Okay, it's a pigeon, but we're going to call it a duck for the purposes of regulating it. And then it turns out that it has quite a different ecological impact. Terrible analogy, but I think you know what I mean. It's also going to be really important to be clear about the purpose of regulating. Why is it that the regulator is stepping in, and what is it trying to achieve? I've bolded a quote here that I thought was really useful here. Instead of considering how existing business forms might be adapted to fit a technology, it might be better to consider how technology might be adapted to accommodate existing business forms and to enhance their effectiveness. It's kind of a chicken and egg question. I'll be really interested to know what you think. Ultimately, they're recommending a principles-based approach, which is where this kind of light touch regulation idea is coming from in the media. Again, quoting from the paper, it is possible that the impact of technology will result in a move away from prescriptive rules-based approach to regulation in favor of a more principles-based approach, one which is supported by clearer outcomes and can better accommodate new technologies and practices.